Langton-Yanowitz from the Yanowitz Law Firm, where we help families protect what matters most. Today, we're going to talk about things not to put in your will. There's a lot of things you should put in your will, but there are some things that you are best left outside of your will. So first thing that you shouldn't put in your will is how your IRA, your life insurance, or your annuity should pass. So your will shouldn't say, at my death, this IRA account should pass to Sally. What you should do with those type of accounts, an IRA account, a life insurance account, an annuity account, is you need to list a beneficiary designation directly on those accounts. So through that beneficiary designation, it will direct how that particular piece of property is going to pass. And really a thorough estate planning attorney will advise you on what all your beneficiary designations should be. We do that when we meet with our clients, and it's really different in different situations, but sometimes we want the life insurance payable under the will. And if that's the case, then we will make the beneficiary of the life insurance your estate. So your estate is code for it's going to be paid under the terms of the will. So if your will says everything goes to John, if John's not alive, to Jim, that means that your life insurance is going to go to John through probate, through the will, and then if John's not alive, Jim. Okay, so don't put that beneficiary designation within your will. The correct place to do that is with actually the asset itself, listing who it's going to go to directly, what trust it's going to go to directly, or to the estate if you have a will in place and it's going to pass under the estate. Second thing you really shouldn't put in your will is a rationale of why you're doing certain things. Why not? Because the will becomes a public document. If your will is probated, it gets submitted to the court, and it becomes a public record. I can look up anybody's will who has been probated in Olmsted County, going through probate right now. It's a public record. And so, if you're putting a message in there that you want to share with your family, but not the entire world, we recommend that you do a side letter, kind of articulating your wishes, why you're doing what you're doing, but not putting it within the will itself, because that does become a public document. Another scenario of why you shouldn't put a rationale of why you're doing. I've had the question, someone will say, my child said they didn't want to inherit anything from me, so I'm not going to give them anything. I'm going to put that in my will. I'm not giving you anything because you said you didn't want anything, okay? So that can create a problem, because then at the time of your death, they can just raise their hand and they can say, well, I never said that. I'd like a piece of the pie now. And so that can create like big ambiguity. So you shouldn't put something like that in your will. Now, I've gotten the question several times, I don't want to leave any assets to this person. Should I leave them $1 in my will so they can't contest it? Okay. And that's a common misconception, that if you leave someone $1, they can't contest your will. Okay. And so we generally don't recommend that. That would be something to keep out of your will. If you truly don't want someone to inherit, that you articulate that within your will. I know that I've provided for 3 of my 4 children in my will. I've intentionally not provided for my 4th child. That's how we would do that. We'd say, considered. I know I have a fourth child, but I have intentionally not provided for them. So it wasn't just like an omission on my part. Or let's say you want to give $10,000 to each niece and nephew, except for you don't like this one niece or nephew. You don't like this one niece. Okay. So in your will, you say, I want to give 10,000 to this niece and nephew, this niece and nephew, this niece and nephew. But, I've intentionally not provided for a niece and nephew that I don't like. So I'm not leaving them $1. You expressly say that you don't want to provide for that person. And then the final thing isn't a good idea to put in your will is instructions on kind of like end of life situations. Sometimes people confuse the concept of a living will versus a will. And a living will relates to kind of end of life planning, making decisions for you in that capacity. Whereas a will is only effective at death. And the sole purpose of a will is to indicate, who's going to get your property at the time of your death and who's going to be in charge of settling up your affairs. Who's going to be the person in charge of paying your final bills, filing your final tax returns, and distributing the property to your family per the terms of the will. So that's the sole purpose. It has nothing to do with, if you're terminally ill and you have to make all these life or death decisions, having a will in place has nothing to do with that. What you instead want to have is what's called a healthcare directive. A healthcare directive includes a living will usually, and within the healthcare directive, that's where you would go into guidance on who would make those end of life decisions on your behalf. Thank you so much for listening. If you have any questions, feel free to reach out to us and stay tuned for more videos.